You know, we learned from Ian Dingwall at the executive directors meeting about the results of the ERISA audits and what the deficiency rates are. And Dingwall shared with the executive directors that he'd been providing the information about firms that might not be appropriately licensed or had not had a peer review. He'd been providing that to the AICPA, and Mark Crocker, representing the executive directors. Of course, there were other executive directors there also, immediately spoke up and said, you know, that's our purview. Why would you not provide that to us? And so that's definitely has now been done. The list of all the firms that performed the audits were submitted to NASBA. We then just sent the list out to the various states of the firms performing an ERISA audit in their state. And Janice will moderate this session, and Jim Brackens of the AICPA, and shoot, I just went blank. Andy Wright, yeah, of the Mississippi State Board. All right. So if you guys will lead us off, then we'll conclude at 4:30 or so, 4:35, 4:37, and then we'll have housekeeping.
We'll be done in time for the gala.
Well, Carlos, you stole all my thunder because you've given my introduction.
I didn't give any numbers.
Most of you that have been around the last 8 or 9 months have heard a lot about the.
Did you turn it on? There you go.
Sorry. Now you can hear me. Those of you that have been around for the last 8 or 9 months have heard a lot about the DOL issue and the problems that were encountered. It was brought to the AICPA's attention actually before March, and they were working on an enormous list that had been provided to them. The AICPA, just so you know, Jim had a conversation with me and talked with me about the issue and said, you know, we don't know what we're going to find. All we know is we have this huge list that we're trying to do a matchup of. But I want you to know that the AICPA is just as concerned as we are as regulators that firms perform audits and reviews and compilations in accordance with professional standards. The difference is they have limitations on what they can do. A firm that doesn't cooperate can only have one meted out punishment, so to speak, from the AICPA, and that is that their membership can be terminated. So what that means is, as state boards who rely on that, we have got to be effective in regulating the peer review process and ensuring that those registrants perform the way they're supposed to. So Jim is going to kind of give us some information about some of the changes, provisions of the peer review process that have occurred subsequent to that, and maybe touch on some things that we may see in the future. So Jim, I'll turn it over to you.
Thanks, Janice. First, I would like to thank those of you that attended our, I'm going to go totally off topic here. Thank those of you that attended our little meet and greet on Sunday evening, where we were giving you an opportunity to experience the new online code of conduct, learn about other things that are going on in peer review other than what I'm going to talk about now, as well as give us some, learn more about our Enhancing Audit Quality Initiative. And that's what I want to point out, is if you haven't seen this paper, the AQ paper, there's still some copies out on the registration table. There's 3 more days before the formal comment period ends, but if you don't want to make formal comment, I'll be around tonight at the gala, and tomorrow I'll be glad to take informal comment. It's very important to us, as Mike was talking about, for the input for the exam. It's very important to us to get your all's feedback on what we're doing. And in addition to that, Tommy Berry spoke yesterday, mentioned that next month we'd be releasing our comment paper on practice monitoring of the future. That's the same topic that Alan Long and Sue Coffey spoke about in June. It's our visionary approach that's intended to marry technology and human review into a near real-time monitoring of engagements with the goal that detecting and preventing audit deficiencies can occur even before the report goes out the door. Again, that's going to come out next month. We anticipate having about a 6-month comment period, and as always, input from state boards is extremely important. But I would like to point out, though, that this paper presents a purposely provocative vision of what the future could be, and I emphasize could be, not will be, could be. It truly is a concept, and it's not meant to provide a cast-in-stone picture of what we anticipate to occur. All input, as I said, is important, yours included, and the input is going to guide the development of the future process. The only thing I can really promise is at the end, the result is not going to be anything like what's contemplated in that paper. It will change. It's meant to start a lot of discussion about where practice monitoring can be down the road several years from now. So now I'd like to turn to the focus of this. I'm still actually on this slide, Janice, but
There's no slide.
Oh, I'm sorry. Yeah, let's go to the first slide. How do we do it? Tommy. Where? We need some slides.
There you go.
Okay, we got it. Yeah, except that's the end. There we go. That's the beginning. All right. Janice gave you an idea of what we talk about in terms of the Department of Labor project. The only thing I want to point out, at the end of my piece, I'm going to give you some updated statistics. But what I do want to point out is, as Carlos said and Janice, you were referring to, we received this list of not quite 5,000 firms of firms that were performing engagements in 2011. The list that you all received that the Department of Labor sent to NASBA and was forwarded on to the states came from 2012. So right there is a difference. I want you to make sure you do understand there's a difference. And in addition, the list we received from the Department of Labor was only for plans that were located in states where peer review was required for licensure in 2011 and did not include members of our Audit Quality Center. And the reason is the Department of Labor is just asking us one thing. They wanted to know whether these firms were enrolled in peer review. We're allowed to say that. That's all they wanted to know. They were interested in the same thing you all are, is a firm properly enrolled, and they wanted to know themselves. We took that a step further in looking to see whether the firms had properly included a employee benefit plan audit in their most recent peer review, and as you know, the results were disappointing. And again, I'll tell you where we are on that in a minute. What I want to point out with this slide is that the Department of Labor project was not the first time that the peer review board became aware of firms failing to appropriately report all of the engagements in a peer review. We had earlier, we'd had an initiative not nearly as comprehensive, looking at the Federal Audit Clearinghouse. If you're not aware, that's a federal database. That's where, when firms perform governmental audits in accordance with OMB A133, the audits have to be filed with this database. So we had become aware, in looking at some of the audits filed there, that we had firms that were not reporting governmental engagements or were not properly enrolled in peer review. So as a result of that, the peer review board in January issued recall guidance, which, as you see up on the screen, we're going to, Andy and I are both going to be referring to this as old guidance and new guidance. So this was the old guidance that was issued. But before I start talking about the old guidance, I want to jump a little ahead. I'm going to come back to the old guidance. It'll make sense in a minute. Earlier this year, the peer review board issued some guidance on non-cooperation. This is the guidance that's followed for when we can refer partners to ethics and terminating the firm from the peer review program, terminating their enrollment. The guidance that was issued did two things to strengthen our procedures. The first dealt with a representation letter, very, very similar to what's done in an audit. In a peer review, a reviewer will give a representation letter to the firm that has to be signed by the firm at the conclusion of the field work or before the report is issued. Very similar to an audit representation letter. We've had this for a while. There's nothing new there. What is new, though, is the representation letter now it contains not only a representation that all of the engagements have been properly reported to the reviewer, but that the firm is acknowledging that if it's subsequently found they did not include all the engagements, that engagement letter will be turned over to ethics, and from which the partner signing that firm may very well find action for an investigation for acts discreditable. The firm could be terminated from the peer review program. What's important from this is that two things. One is the peer reviewers to tell the firm about this at the beginning of the review, that this rep letter is going to have to be signed and what's going to contain. So the hope is that this enhanced communication will take care of the firms, and I will tell you there have been some firms that were honest mistakes. They just inadvertently didn't disclose. They may have combined the EBP engagement in with the regular audit. There's a variety of areas. Hopefully with this extra communication, they will fully disclose and we won't have a problem in the future. That's our first hope. But the second piece is this representation letter is going to be retained by the administrating entity, the state society, and will be retained until the next peer review. That's important because that letter will then become prima facie evidence. If we subsequently find there's a problem, will become prima facie evidence in an investigation in a case that we would take against the individual in the firm. The other thing that bullet in there talks about a no ANA letter. I have to explain this. Firms are able to enroll in peer review even if they are not performing a test and compilation services that require a peer review to be performed. One would say, why would you want to do that? If you're not performing services that would require peer review, why would you enroll in peer review? Well, there's a variety of reasons. There's even at least one state that requires enrollment in peer review to get a firm permit. So there's a variety of reasons firms do this. Well, when they do, on an annual basis, we send out a confirmation to the firm requesting, asking them whether they had performed any services in the prior year that would require a peer review. And if they did, they would be enrolled, they would be scheduled, a review would be scheduled. If they say they haven't, they are signing this letter acknowledging that they are representing that they have no ANA engagements. Well, similar to the representation letter, we've now modified that no ANA letter so that the firm understands the consequences of them not signing it, that it's going to be retained and would be used in a case against them if we find out later that they had misrepresented. So now let's go back to the first bullet. In 2012, as I said, the peer review board issued its initial recall guidance. I guess I need to point out something that's unique to peer review. This is what gets tough doing these talks. In peer review, sometimes we make an analogy of the peer review report to an audit report. But there's one really big difference. In an audit, the firm, once they issue the report, it's out there, and if they want to recall it, it's their decision, period. It's their audit, it's their report. Peer review, it's not quite the same. It's a two-part process. The reviewer issues his or her report, but then the report has to go to the state society, the administering entity, the peer review committee, where they, in the vernacular, they approve that peer review. We call that accepting the peer review. When that second step occurs, the administering entity issues an acceptance letter. This is important to understand for me when I explain the recall guidance. What happened in this guidance in 2012 is the peer review board stated that if information comes to the attention of the peer reviewer that they were not aware of certain circumstances or information when they did the review, and it would have caused them to issue a different report, they should recall their peer review report. In other words, if a reviewer had initially issued a pass report, subsequently finds out that the firm did employee benefit plan audits and did not tell him or her about it, and That could have caused a difference in the report, could have caused a pass with deficiency or fail potentially. Then the peer reviewer should recall his or her report. Well, it goes a little further though. If the reviewer says they're not going to recall the report, the administering entity's peer review committee has to decide whether or not to recall the acceptance letter. The end result of either the peer review report's recalled or the acceptance letter is called, the result is the same. The peer review is null and void. And at that point, the State Board of Accountancy is notified through facilitated state board access that FSBA information has changed, and that serves as notification of the recall. The problem with this guidance, though, is there were some consequences that were not anticipated by the peer review board, and I'll explain that a little bit more. It'll be logical on the next slide to really explain what the consequences were. But what they did in May, the peer review board revised the recall guidance, again, what we're going to call the new guidance. And what changed is that in certain circumstances, and the most obvious is the EBP area, but in certain circumstances, if we become aware, collectively we, that could be the state society, the review, or the AICPA, become aware of information that we can tell just by the information that the peer review report itself was not appropriate, was materially misstated, then we're going to take action. Now, to do that, as Andy told me, I'm going to have to explain what we call a must-select engagement. There are certain engagements, including employee benefit plan engagements, governmental engagements as well, and others, that if a firm performs even one of these engagements, even one, it has to be looked at in the peer review. That's why we call it must-select. You must select that engagement. Well, not only does that have to be done, but the peer review report itself is modified to indicate that such an engagement or industry was looked at. So in the case of the employee benefit plan situation with the DOL project, if the firm had not reported they were doing EBP engagements, the reviewer wasn't aware of it, they didn't look at one, and the report didn't indicate one was looked at. Well, the peer review board determined that's an example, there are a couple others, but that's an example of a materially incorrect peer review report. So what changed is that when we receive this information, and AICPA staff verifies the information, notification goes to the administering entity to notify the firm that the acceptance letter is being recalled, period. There's no decision. It doesn't go to the report. It doesn't go to the peer review committee of the state society. It's just done. It is to be done. We also notify the peer reviewer, and they're expected to recall their peer review report. But again, it really doesn't matter. That acceptance letter is going to control the result, and the state boards are then notified. In essence, and the firm is then has to do a replacement review and such as well. But the important thing is that's changing the timing, and I'll explain that and give you an example on the next slide as to what that means in practical instance. The other thing I want to point out, actually, we're missing the very bottom bullet, Janice, or at least we are. I don't know if it's, I don't think it's not on the slides up there either. Oh well, I'll just speak to it. In September, additional guidance was issued. What happened is the January guidance and the May guidance, because the January guidance was effective for prospectively for reviews were started being performed in this peer review year, basically, and the May guidance was retroactive. It actually created a conflict that was going to occur. I won't go into the details, but basically it allowed for a process to resolve that conflict. We're now, in essence, going to have a hearing panel that would determine whether a firm is going to go to non-cooperation and be terminated versus be allowed to have a replacement review. But again, I don't have the time to get into a lot of details when I mention it. The bullet that you cannot see on the slide, the very bottom one, is what, as Janice said, what are we doing now? Tommy also touched on this one as well yesterday. I mean, we're continuing to mine data. We're continuing to look at the Federal Audit Clearinghouse. We're continuing to look at the Department of Labor's EFAS-2 system and comparing with our records. That will be an ongoing initiative. But more importantly, we are going to be start collecting employer identification numbers and and with a collaborative effort with NASBA, it's in the exploratory stages, but we really believe this can be done. If we can, through the ALD, if the state boards also start collecting employer identification numbers, create a field and pass it to NASBA, we're going to be able to compare data, and we're going to be able to provide reports automatically, both the state boards and AICPA, of firms that are not properly enrolled in peer review. That's our first step. And that right there is going to be a tremendous help. We would like to expand that down the road potentially. Now I'm speculating and I'm not going to promise anything, but we'd love to expand that to where we're having similar comparisons all through the ALD of the federal databases and potentially others, so we can catch these firms very quickly. As Janice said, we have the very same goal here. And old guidance versus new. Really, it's about time. The old guidance, as I said, the peer review committee was able to determine whether or not to recall the acceptance letter, and that would take time. I mean, first the peer reviewer had to make the determination whether he or she was going to recall the peer review report. The peer review committee would have to decide whether to recall the acceptance letter if it hadn't been recalled by the peer reviewer. All of that takes time for the committee to meet. That would take time. The new guidance, as I said, it's virtually automatic. The firm is notified that of the evidence that demonstrates that there is an inappropriate peer review report, and they're basically given 15 days to provide that there is some mistake, fraud, or whatever. But it's virtually automatic. And the second is when I want to speak to something that was occurring in the old guidance. This is what I meant by there was something occurred that the peer review board really hadn't anticipated. This wasn't in the guidance, but it wasn't prohibited, what I'm about ready to tell you. What some state societies did when they received this information about the peer reviews, the not including employee benefit plan engagements, is they, rather than going through the process, they said, look, what we want to do is we want to get these firms, we want these engagements looked at as quickly as possible. We want a new review performed that includes one of these EBP engagements so that we can either find out whether the firm is doing it right, and if they're not, get remedial action and process. That was their thought process. That's what's in the public interest to get these looked at. So what they did is they'd go to the firm and say, look, here's the problem. If you agree to have an accelerated review or a replacement review, then we won't recall the acceptance letter, and the reviewer wouldn't recall the peer review report. Fine. I mean, it actually could speed up the process there to a certain extent, but as I said, rather than going through these other steps. The problem with that, and this was the unintended consequence, is the state boards then do not become notified of a change until that replacement review is performed. And that bullet says as much as 7 months and maybe more. What that refers to is the peer reviewer, it could take 90 days, or the firm's given 90 days to have this replacement review done. Then the peer review committee has to accept it. Our standards allow for up to 120 days for that to be done, and sometimes it can take longer because if there's problems, they send it back to the reviewer to go back out to the field. That ever happened to you, Janice? Never happened to me either, but it does happen. So, that whole process, in essence, was going to take a long time. So state boards aren't being notified for several months. As I said, the new process, it's 15 days. It's about as quickly as it could possibly be done. So that's the real difference between the old and the new. What I want to point out is, I'm about ready to give you the statistics, but a number of the reviews that did go through this old process where they were having this replacement review. And as a result, some of them are probably still out there where there has been no state board notification, again, because it's a replacement review, it's not a recall. We've had a number of inquiries from state boards saying, I thought we had more than these, where are the reviews? They're working their way through that system. It is what it is. We had to change, the guidance had to be prospective, not retroactive in that regard. But I can assure you anything that's happening going forward is under the new guidance, and you will be getting that very quick notification. And now the statistics. Almost 5,000, nearly, close to 5,000. 4,918 is the population. That was the number of unique firms that was submitted to us by the DOL. The good news is almost 4,000 were completely in compliance, 79%. Of course, the bad news is that means 21% of the firms were not, or potentially are not in compliance. I have to say potentially because we're not quite through. That's unacceptable, totally unacceptable. So going down the list, just to tell you where we are at this point, of 491, we absolutely know we're not in compliance. Absolutely, positively could determine that they were not in compliance. 109 of those have been referred to our ethics division because the firms were either not enrolled in the program at all or had signed one of those no A&A letters saying that they weren't doing accounting and auditing work when clearly they were. To me, those are the worst of the offenders. 251 have been recalled and a replacement review required, and some of that process is finished, some have not. They're going through it. And then 131 are the ones that I mentioned under the old guidance, the ones that were not recalled and they were getting replacement review. I mean, in complete disclosure, that's not complete. That's not all. Actually, when we started looking at this list, we were able to determine some of the firms are in the process of having a review or were scheduled, and rather than going through the recall process, we just made sure one was an EBP engagement was included in that review that was in process. So it's also in that 131 number. Now there's 266 that the slide says unable to identify in PRISM. PRISM is our database and peer review. These are firms we just don't know anything about. We can't find any record of them at all. They're not AICPA members. We don't know who they are. So what we are doing with these firms in the interest of due process is we're in the process right now of sending them letters, certified mail, return receipt requested, so we have proof of delivery, saying unless you can let us know in X number of days, I think it's 15, honestly, it's fairly short time, unless you can provide evidence that you're enrolled in peer review, that we've made some mistake somewhere, you're going to be sent to your state board of accountancy, and that's going to occur. Those letters will be coming out when you see them. They're going to come over my signature. Be looking for it. The other 277, it says still investigating. Most of them were investigated once. The vast majority are probably going to fall in that bucket of referred to ethics, but bear in mind this process has been going on for a long time. I should mention, and I'm really looking forward to Andy hopefully encouraging you all to do some of this so it can be done quicker. This is a huge effort without employer ID numbers to match these firms. That's why it's taken us a long time. Most of the 277 are firms that we initially found that appeared not to be. We found the firms. We could identify them. They didn't appear to be enrolled. It's not a no A&A. It's a non-enrolled situation. What staff is doing now is going back and taking another look because it's been a while, and we want to make sure the firms have not since enrolled. But if they have not enrolled, they're going to be in that same bucket of 109 that get referred to ethics. And with that, I'm going to turn it over to Andy, who's going to show you how state boards can be doing what we've been doing in a fairly expeditious manner, and hopefully it's a smaller population than we have, and I encourage you to do this, and then let us know when you find the problems.
Thanks, Jim. We can fast forward through the first couple of slides here. That's just our information. I list the resources on the web because part of what I'll talk about is how to use this Department of Labor Form 5500 filing search on their website, where you can find all the detail, the complete Form 5500 and the independent auditor's report there. I've got our web address too, because we divided this up into two different goals or objectives. One was to identify if the firms were licensed or registered with our board, because that's required in our state law. And we really don't have any choice about that. We have to get them to get registered. Let's see. Okay. The Department of Labor, Ian Dingwall's group, and a fellow named Marcus Aaron, I don't know if either one of them are here today, were a big help. And Marcus in particular helped us with using that search site. Jim's already talked about that they got a 2011 list. We had a 2012 list. We sorted it. It was an Excel spreadsheet format, sorted it alphabetically by firm name. There was an acknowledgement ID that got added onto the version of the list that NASBA provided us, which could be a shortcut to searching on that 5500 site. We identified approximately 100 unique firms, actually 101, that performed, I believe it was 393 audits of employee benefit plans that were based in Mississippi. And as I mentioned, if they're doing an audit of a Mississippi-based entity, they have to be permitted through our board by statute, and I list that statute there. And we found 12 of those firms preliminarily. Okay. We also identified 5 firms with a possible improper peer review report. There was no mention of the EBP audit on there. Those were all Mississippi-based and licensed firms. 4 of the firms only did 1 employee benefit plan audit that year, and 1 of the firms did 2. 3 of the firms we verified they did not perform that subject employee benefit plan audit in other years. And in fact, 2 of those 3 firms have since merged with larger firms that have acceptable peer review reports. There were 2 firms where it really looked like they did not have the proper peer review report, but one was under the old guidance that Jim mentioned. And I don't know if we got notification from AICPA, but we did notice the accelerated peer review that was only about 18 months after the previous peer review was posted to facilitated board access just a few months ago. Okay. He says we should have gotten notification. Okay. Also, this list from NASBA lists the employee identification number of the plans, and we'll talk about on the next slide that Form 5500 search site of Department of Labor, and you could use that employee ID number to pull up all years of 5500s and audit reports that are out there. And just for your information, usually that independent auditor's report is towards the end of this one PDF file that's each year's Form 5500. It might be the first 20 or so pages or the 5500 in schedules, and the auditor's report would start on page 21 or so. Here's the search criteria you can use at that website. It's all relative to the plan. We noted, and I guess we could ask Department of Labor at some point if we could get something on there where we could search by the firm or the firm's employer ID number. Those are not search criteria at the current time. Neither are city or state of the plan. I mentioned that acknowledgement ID, that you could copy and paste that from the list that NASBA has given us, and that makes the search a little quicker. But that'll only bring up that 1 year, 2012. Further work that we've done, we discovered that 3 of those 12 non-registered firms were actually auditing an out-of-state plan. We just had on the first page of the 5500 a Mississippi address, but that was not the home office of the plan or the sponsor. And we did various things to verify that. We discovered that one of the 12 non-registered firms really was registered. The name of the firm was slightly off on the list. It said and company, but the firm's actual name was and associates. And in the 5500, I think it helped that we had the firm's employer ID number there just to verify that the one we thought was the correct one was the correct one. But we had another problem there because they should have already had a peer review. They're out-of-state firm. From what we could determine using the Federal Audit Clearinghouse also is the time had passed for them to have already had their peer review, and they just recently enrolled in the out-of-state peer review program. But it didn't, one of the firms did not have the EBP audit fall within their peer review year. Their peer review year ended May 31, 2012. The plan audit was December 31, 2012. We got a letter from them that they hadn't done any peer review audits in the past, because if they had done December 31, 11, it would have fallen within that year. We didn't stop there, since I knew how to go back and look at prior years on the plan, and we found that a different firm had done the employee benefit plan audit. It was a Mississippi licensed firm with an appropriate peer review report. So, one thing I wanted to add before questions is, most of these are dabblers. You know, I mentioned just they only did one, they only did two. There were a few in the 12 that actually did several nationwide, but only one in our state. But one of the ones who responded to our inquiry said, well, I only did that one year, dadgummit, helping out a buddy around the corner. So I went back with the tools on the search site and looked up the prior year and the prior year of that and the year after, and it was one firm that's not permitted in our state. So we've contacted them, so we got a 13th out of it.
So I think you all can see just from Andy's comments and presentation, this is not an easy process. That's just one state that Andy was dealing with. Jim and them were dealing with a population of 5,000 from all the states. So it has been a challenging process, but I think the important thing as state boards, I know many of you have received the list, and the first process that you did was to determine if those individuals were registered in your state, and you've taken the appropriate action. But please don't stop there. That isn't the whole purpose of this process. The process is to ensure that those firms did have the appropriate peer review or had a peer review if they were required to. So we just wanted to kind of give you a flavor of how this process had worked. I know we're out of time. Jim will be here throughout tomorrow, and Andy, you will be also. And Jim said he would even answer questions at the gala this evening.
Yeah, make sure I haven't had a couple glasses of wine first, but yeah.
So.
We want to thank the panel for a very informative session, and